Well, good evening, everyone in Alberta, Canada, and beyond. It is Wednesday, October 30th, 2024. And I'm Kerry Lambert, and I welcome you to an evening of solutions for a new Alberta brought to you by the Alberta Prosperity Project, also known as APP. APP's purpose is to educate, inspire, and unite all Albertans, businesses, and organizations to protect the prosperity, individual freedoms, rights, and self-determination by empowering the Alberta government to restructure Alberta's relationship within or without Canada. If you can, please share this webinar. We are on Facebook, YouTube, Twitter, LinkedIn, Rumble, as well as after this live, we're also on other video and audio sites like Apple, Spotify, BitChute, and Vimeo under the Alberta Prosperity Project, as well as under the Chris and Kerry Show. One thing I did want to bring up is go and find out more about the Alberta Prosperity Project. If you can, go to the website, albertaprosperityproject.com, and take a look. We are advocates for the 5 pillars that we're looking at: taxation, pension, policing, immigration, and employment insurance, and a lot to talk about, especially on this episode. I'm not going to dive or go too much into this about the Alberta Prosperity Project, but at the same time, I do want to say there's been a lot of rumblings about what the Alberta Prosperity Project is and how we've been dealing with everything that's been happening in terms of government. And right before we even get our guests on, I just want to reiterate that one of the big things that drew me to the Alberta Prosperity Project initially was that they were in line with everything that I valued in terms of freedom and sovereignty, and whether or not you want to be part of Canada or not. I think this is a great educational group that is involved in this. And I'd like to say hello to everybody that's out there that's involved with APP, and that you guys are all doing an amazing, wonderful job. And that I'm happy to be part of this group and spreading the word on everything that is dear to me in terms of freedom and prosperity in Alberta. And so that's what I wanted to say. And because I know a lot of people out there are saying, well, you're siding with the government and whatever. You know what? If it was the NDP that was in leading the government right now, in the provincial government, we'd end up having to talk to them face to face. And the fact that we actually have a conservative government right now that we can actually have these conversations with, I think that's really important. So that's how I wanted to start this entire thing. And if you can, there's lots of things that we are doing. We have a Take 5 initiative, where you can take 5 minutes and repost a lot of our social media. Repost this, share if you can, as well as take 5 minutes and have a conversation with other people. And if you can, please donate, because it takes a lot of money and a lot of time and effort in order to pull these things together. $5 a month would be amazing. Just imagine how many members we have. That would do a lot. That would be absolutely amazing with this. And without further ado, what I'm going to do is just get right into this. Tonight's episode is called Pre-UCP AGM and the Alberta Bill of Rights. Yes, our provincial government's party, the United Conservative Party, is holding the annual general meeting this weekend, Friday, November 1st and Saturday, November 2nd, 2024, at Westerner Park in Red Deer. Part of that is to vote on the governance and policy items, which we discussed with Dr. Dennis Modry and Chris Scott on a previous APP webinar on October 16th, and you can view that on our video channels. We also spoke with Mitch Sylvestre and Scott Payne on October 2nd about the Bill of Rights and how it was to be introduced into the lecture. And going even further back, we also talked about the Bill of Rights way back on July 31st with Leighton Grey. So we've been talking about this for quite a few months, and we're quite excited and happy to have it get read at the legislature this past Monday, October 28th. But there have been some concerns on what was actually introduced and some of the language in that. So we have a few guests tonight to discuss this hot topic this week. We have former CEO from the Alberta Prosperity Project and founder APP, Dr. Dennis Modry, who will hopefully be joining us a little bit later, as well as we have Leighton Grey, the lawyer, and amazing, and he's been on our webinars many times, as well as we have Scott Payne back and possibly a few more guests to weigh in on all this. Unfortunately, Mitch Sylvestre from the Black Hats and the supporter of the gun rights won't be on tonight, as he's currently at a meeting to talk about the Bill of Rights with the UCP board. But depending on how long this webinar goes, I may hear from him before we end, and we'll see how his meeting went. Aren't live shows fun? And of course, this is a live webinar. So if you want to make some comments or ask questions, please put 3 question marks before your question. And that way I can flag it and I'll definitely try and answer it. And if you can, again, please share. We want to get this thing going a little bit viral tonight, because this has a lot to do with the province going forward. So with that, I'm going to bring on Leighton to start the conversation with. Hello, Mr. Grey. How are you?
I'm doing well. Thanks for asking. As you can see, I'm not in my office today. I'm in a hotel room somewhere in North America. Could be Las Vegas. I'm actually down here with my son, who's joined a hockey team down here in Henderson, Nevada, for the rest of the year.
Oh, seriously?
So,
that's awesome.
Spending a few days in the desert. It's been a nice little break, except for all of the Alberta politics that just follow you wherever you go. If you're me, that's what happens.
I know. Now, are you going to be back for the AGM this weekend?
We're flying back tomorrow, late tomorrow night, so I should be back in time, and I'm going to do my best to be there. But if I'm not there, I mean, there would be a lot of really great people there to
absolutely. And even, I already know a few people who thought that they would be able to make it, and they can't make it this weekend. And but we're still looking at like 5,600, maybe even close to 6,000 members at
amazing.
The AGM.
Yeah.
So obviously, what you've been hearing, you are not in Alberta, so you're hearing it. You're hearing it through tweets. You're hearing it from phone calls, through text messages, like I have. My phone has blown up in the last couple of days. So do you want to maybe, again, we've had you on before. We talked about what the actual Bill of Rights was, why it was changed, what was going to happen with that. And then we actually talked about the process of, getting on onto the floor and what the language verbatim was going to be. And then it was it was introduced on Monday. If people don't understand the concept of how bills get introduced, I'll get Leighton to maybe explain just that brief part, because I did manage to go on to the provincial site, and I screen captured a lot of the videos of the introduction of the bill, as well as Daniel Smith's reading of it, the second reading. And we may play some of that, and if not, we'll just refer back to that, or I'll even tag these and anybody that's actually following the Alberta Prosperity Project, I'll put that in a separate little folder for people to look at, because I think that's important too, is to see not only the meat and potatoes, which obviously we're talking about today, but the process in order to get that done. So with that, Leighton, how does a bill get put in?
Well, in our system of parliamentary democracy, a bill is introduced. The bill is the name of a law before it's passed. And what happens is it's introduced in the legislature. It goes through 3 separate readings, and during that time, it will often go through a period of debate that can result in amendments. But ultimately, then the House votes on it, and if it's passed, then it goes to the Lieutenant Governor for royal assent. She would sign it, and then it becomes law in the province of Alberta. Now, since we have a UCP majority, we should anticipate and expect that this bill is likely going to become a law sometime in November. This, whatever you think about this bill, and there's a lot of controversy surrounding it, that's what it looks like is going to happen. Whether or not there are going to be any revisions or changes to it, that remains to be seen. I think that I'm confident that I speak on behalf of the Black Hats group, who were instrumental in making a submission to the government about what we think the bill should look like. I'm confident our group thinks that it needs some significant amendments to it in order to fulfill the original intention that we had, and that was to secure the rights and individual rights and civil liberties of Albertans. I would say the introduction of it this week, to quote Charles Dickens from A Tale of Two Cities, the opening line was, it was the best of times, it was the worst of times. There are good things about the bill that we're happy about, but there are a couple of things that are very, very seriously concerning. John Carpe of the of the JCCF actually wrote a very engaging piece on it. He called it 2 steps forward and 1 huge step back.
Yeah.
And we can talk about that if you like.
And I know Catherine Kolchuk even wrote an article on that too. What's this? In Alberta, rights are a bridge to expand rights.
Yes.
And there's a lot of conversation that could be had about those.
Yeah.
And they're both lawyers as well as yourself. And so, you know, us laymen, we don't understand how the verbiage of these laws basically goes through. So we're definitely asking for your help to interpret that and to tell us what the good and the bad are of these laws.
Sure. Well, just sort of hitting the highlights, and I'll say that I've heard from Brian Peckford, who's he's the last living architect of the charter. In fact, was largely responsible for drafting Section 1 of the charter, which is something that he wrote to me today that he sincerely regrets, and I'll explain why. And also heard from Bruce Party, who's one of the country's leading constitutional experts from Rights Probe and Queen's University Law School, and he thinks he shares our concerns about one part of the bill. But before we get to that, I mean, there are some good parts. Firstly, the Bill of Rights does recognize individual bodily autonomy. This is an important change. Albertans went through COVID. They experienced, especially those of us who decided not to participate in an experimental drug trial, we suffered persecution, all manner of discrimination. The Premier famously said right after she became the Premier that she thought that the unvaccinated people of Canada and of this province were perhaps the most discriminated against group in recent memory.
That's right.
She was castigated for that, but it was true. And true to her word, in this Bill of Rights, there is now recognition of individual bodily autonomy, which means that if a government or an employer or someone else tries to force an individual to engage in, to violate the integrity of their body, forcing them to take a drug, for example, to save their job or whatever, that would be regarded as a human rights violation in Alberta. And that's true for the first time, not only in Alberta, but really anywhere in Canada. So that's a significant thing that is important for Albertans. And it's an expansion of the existing legal protections for individual rights and freedoms in Alberta and the individuals who live here. That's an important one. Secondly, there is some wording to protect the rights of lawful firearms owners in terms of property rights. We think that that wording needs some tweaking. I'm going to let Scott Payne speak to that. And there's also a recognition of property rights generally, and this is in relation to the assertion of the provincial jurisdiction and sovereignty over property and civil rights, which is under Section 9213. There's also a re-expression of some things that have been rights and freedoms in Canada for a very, very long time, and that are recognized in the Charter, things like freedom of speech, things of that nature. So overall, I would say, I agree with John Carpe. There are some very good things in this bill. For my money, though, I have to say that there's something that is in this bill that absolutely must go. And if it doesn't go, then the entire exercise may be futile. And I can explain about what that is if you like.
Yes, please do. And I'm actually looking it up right here. I've got got it.
So I'm going to dive. I'm going to take people. This is painful, but I'm going to ask people to cast their minds back to the dark COVID period of 2020 and 2021 and 2022, leading into the Freedom Convoy in the early part of 2022. It's hard to believe that's nearly 3 years ago now, but it is. But it's still vivid in many people's memories. It's indelibly burned. They'll never forget the images of what went on there, things that happened that really were beyond belief. And one of them was the behavior of our courts. Prior to COVID, most Canadians slept confidently at night and put their heads on their pillows, believing and knowing that there was something called the Canadian Charter of Rights and Freedoms. and that it protected them from a government violation of their individual rights and freedoms, things like freedom of speech, freedom of expression, freedom to associate, freedom of religion, freedom of mobility, protection against discrimination on the basis of who they are and their decisions and things of that nature. Of course, what we discovered during COVID is that those rights were subject to the public policy discretion of the government, and that these rights were not inviolable. In fact, they were violable so long as a court was satisfied that the government was acting in the best interest of society and trying to preserve our safety. And so in each case, when lawyers like me went to court in British Columbia to challenge lockdowns, or in Manitoba to challenge lockdowns, or in Alberta to challenge lockdowns, in each case, what happened was the government would readily admit that they violated constitutional rights and freedoms, but that it didn't matter, because under Section 1 of the Charter, it says that the rights and freedoms recognized and declared in the Charter are subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Now, that sounds a little bit like Kamala Harris or Justin Trudeau, so I'll explain. What that means is essentially there's an override provision. There's a saving provision, so that even in severe violation of constitutional freedoms, for example, let's take mobility rights. What happened to all of us because we couldn't get onto a plane, a train, or a ship anywhere in Canada. We couldn't even leave our country. That was a severe violation of Section 6 of the Charter. But that was considered to be overridden by the overarching safety concern that this quote unquote existential threat, the COVID-19 virus. And to understand how extreme this was, we went to court in December of 2021. This is during, I guess, the second wave. And this is when the Kenney government imposed really the most severe set of lockdown restrictions. And we went to court, myself and Jeff Rath went to court to try to get an injunction against the government of Alberta to stop these lockdowns. Okay. We had our entire case was there. We had all of our science. We had an affidavit from Jay Bhattacharya, who was even then, and especially now, is recognized one of the top epidemiologists, one of the top scientists in this field in the world. And so we had our whole case. The whole case that we presented at trial, we actually presented in that injunction application. And what we said was essentially that what was in the Great Barrington Declaration was true, and that is that COVID-19 did not pose an existential threat to society, and that there was no reason to impose all these lockdowns, and that the lockdowns themselves were going to cause more harm than the virus ever would or could. And that was the evidence that we presented. It was all there. Well, the government of Alberta produced no evidence. They simply produced an affidavit from Dr. Hinshaw saying that, in her opinion, COVID was serious and that these lockdowns were necessary in order to protect the public. And the judge agreed with the government. And that judge, in the absence of any evidence, in fact, the judge, more than that, gave them until July of the following year to produce their evidence. And I can tell you, when they finally produced it, it was junk. But in the absence of any evidence, the court took what's called judicial notice of something called a pandemic and suspended the individual rights and freedoms of every single Albertan, 4.5 million of us, in the absence of any evidence. And then ultimately, the courts in BC and Manitoba and Alberta found that, in spite of all these these charter violations that were committed by governments over lockdowns, over vaccine mandates, that actually that was allowable because the government was acting in our best interests. That what they did was demonstrably justified in a free and democratic society. So flash forward to the Black Hats gang. the gentlemen who are going to join your program in a few minutes, LeVar and Scott Payne and Ian Parkinson and Matt, they're going to tell you that what I've just told you, that COVID horror was the main reason why they got involved in individual rights and freedoms. And they got together and they dedicated themselves to creating a new piece of legislation, a new Bill of Rights in Alberta that would not have that Section 1 saving provision in it. Because we learned through the COVID era, because of that Section 1 of the Charter, that it rendered all of those rights and freedoms in the Charter, as beautiful as they sound, meaningless. And so we submitted a 22-point list of freedoms very clearly expressed to the government. I was on a Zoom call on the weekend. The Premier was on. There was about 30 of us or so. She said about 95% of what the Black Hat Gang had submitted to government was going to find its way into the bill. But for the very first time, we discovered, to our great horror, that the very wording of Section 1 of the Charter has been inserted into this bill. And so what that means is that it makes the government supreme. This is under subsection 1 C sub 2. And it basically imports the very wording of Section 1 into the bill. This is specifically and by design left out of what we submitted to government. The government, in its wisdom, inserted this back in. And what it does, essentially, this clause makes the government supreme. It makes the government able to go to court and say, in the situation of a climate emergency or a pandemic or some other type of declared emergency, that it is supreme and that it can violate the individual rights and freedoms in the bill. And in my respectful opinion, it makes those rights, based upon the experience of COVID, it makes those rights and freedoms meaningless. And I'll go a bit further. And some people might say this is in the realm of conjecture, but I would argue that's not true. I would say this is more in the nature of prospective legal analysis. I suspect strongly that the reason why this Section 1 clause found its way into the bill is because the government of Alberta is presently facing COVID litigation. Our good friend Chris is a representative plaintiff in one of those actions. And in those actions, part of what's claimed are violations of individual rights and freedoms, the violations of the Bill of Rights and of the Charter. And I think that the government of Alberta is anticipating being sued for it's anticipating human rights violations claims. And so what they did, in order to protect themselves, to protect the government, they inserted this Section 1 clause so that a person sitting as an arbitrator in a human rights tribunal or sitting as a court in a case, a class action or whatever, would be able to find that even though the rights that are set out in the bill are violated, let's take gun confiscation or even the protection against violation of bodily autonomy, that those could be violated by the government, but that those freedoms those violations would be demonstrably justified in a free and democratic society. And what we learned during COVID quite clearly is that the courts are much more inclined to side with the government and apply this type of saving provision than it is inclined to find that the courts overstepped and overreached and exceeded their authority. In other words, that what they did is not demonstrably justified in a free and democratic society. In fact, the only cases that I know about that have applied Section 1 against the government are, of course, the famous Mosley decision, which involved the Emergency Act, which, of course, the government of Canada has appealed, and some of the cases involving the military, where the military members were forced to vaccinate under threat of court-martial and being removed, being kicked out of the military entirely. Those are the only situations thus far that I have seen where this Section 1 has been considered and there's been a finding against the government. And so, given the behavior of the judges during COVID, in cases of this kind, I'm very, very concerned that the government of Alberta has inserted this provision in order to protect itself from liability, and it's placed itself above the interests of individual Albertans in terms of protecting their rights and freedoms. And I think that this is well known, for example, to our premier, who has been very outspoken. And she talked before she became the premier. People who listen to her radio show or her podcast, they know that she was very outspoken and critical of the courts in the way that they applied Section 1 of the Charter. And so to me, it's all the more consternating and indeed frustrating, beyond disappointment. It's just frustrating that, we've put so much time and energy and thought and work, really, not so much myself, but of course, people like the Black Hats gang, and of whom I'm just sort of an adopted lost child. But these guys, these guys really did all the work. They deserve all the credit. And to me, it's just it's really frustrating that after all that work, we have this provision put in, which, as I say, effectively, based upon recent decided cases, makes many of the rights in the bill basically unenforceable. It reduces them to the level of privileges. And the other thing that's really concerning is the concept of our bill, and some people may not like this, but our bill was fundamentally Christian in its foundation and its values. And it said right in the preamble that these rights and freedoms essentially are bestowed, they're natural rights. They're bestowed by God. They're inalienable. And that's very important because even if you're not a Christian, even if you don't believe in God, to quote Richard Dawkins, a world famous atheist, you want to live in a society that has those Judeo-Christian values because they presume that these individual rights and freedoms are God-given, and therefore that a government cannot take them away. And what this provision that's been put in here, this importation of Section 1 of the Charter, what it does, it essentially says that rights are not things that are bestowed upon us by God, that are inalienable, that are inviolable, but in fact, that they're bestowed by government, and that government can violate them when they think it is necessary. It's a very, very paternalistic view of rights. It treats Albertans really like children. And there's a very authoritarian aspect to this. And Section 1 was the brainchild of Pierre Elliott Trudeau. That's why it's part of Canadian law. There's no equivalent of this Section 1 provision of demonstrably justified and free and democratic society. There's no equivalent, for example, in the United States Bill of Rights. And actually, we didn't have, before we had the Charter, we didn't have these limitations upon our common law rights and freedoms either. And that's why, for example, during COVID, I tell people about this and they're shocked by it. During COVID, when they tried to shut down the churches in Scotland, Scotland has no Charter of Rights, has no written Bill of Rights. They have the common law rights and the 1688 English Bill of Rights that we had prior to the Charter. And when the government tried to close the churches in Scotland, they couldn't. The courts couldn't uphold it because it was a clear violation of freedom of religion, of the right to worship. And so in Scotland, where there's no Charter and no Bill of Rights, those churches stayed open. And in Canada, as you know, those attendance at those churches was restricted, and some very principled and fine men spent a lot of time in jail. People like Timothy Stevens and Pastor James Coates and Arthur Pawlowski, spent time in jail because of it. And so this section of this Section 1 of the Charter that's been imported into this Bill of Rights, in my respectful opinion, has no place in this bill. It shouldn't be here. I think it's an offense to Albertans, and it certainly offends the spirit of what the Black Hats were trying to do.
And I totally agree with all of that, and great insight. I'm so happy that you started off with how all this came to be, to have people catch up on the discussions we've had, like at least 3 of these webinars about the Bill of Rights. My question to you is the fact that they actually use the word demonstrably again in this, as opposed to any one of, just look it up in a thesaurus, verifiable, etc.
Yeah.
Do you think that they use that language specifically because it's already being tried and true through the Canadian courts?
Yes, it's a great question, and I had, if people are interested, I had 3 lengthy discussions on my show, shameless plug, Gray Matter podcast, with Brian Peckford, and each one of those conversations, Mr. Peckford is just off the charts brilliant, and he has deep insight into this wording. In fact, he was at the table, and his understanding of what this word meant is demonstrably. It means that it has to be obvious, clear, clearly justifiable, like beyond doubt, essentially, to a very high standard. That in other words, that onus was intended to be on the government. It would be a very high onus that they would only be able to meet in very exceptional circumstances. And he used the example of, a time of war. Okay. If we're being invaded by another country, which arguably is happening right now if you follow the news in Ottawa, but we're certainly being infiltrated. But what has happened in the context of COVID and some cases leading up to it is that this word demonstrably it's just lip service. It's become meaningless. And I think that, to answer your question, the reason why it's in here is because that word has been interpreted very favorably to governments in recent cases, especially in COVID cases. And it's a very safe thing to do. It's a tried and true strategy to just incorporate the words that already exist in the Charter. And there are many reasons why the UCP government would do that, but none of them serves the interests of protecting the individual rights and freedoms of Albertans. All the reasons for incorporating this particular language really protect government. And that simply is not the purpose of a Bill of Rights. The very purpose of a Bill of Rights or of a Charter of Rights is to place limits, prescribed legal limits on the exercise of government authority. And it's a way of a government saying to the citizenry, you know what, we're going to place limits, legal limits on our own power. We're going to tell you what they are. And so that if we step out of line, if we go too far, you can go before a court of law and you can take us to task. It's a way of recognizing that the power in a free and democratic society like Canada is in the people, and it's not in the government. The government is there to serve the people. And unfortunately, Section 1, in its very wording, and particularly in the way that's been applied by courts, does quite the opposite. It has been used to support and to justify tyranny. It's been used to justify and support violation, clear violation of individual human rights and freedoms. It's been used to justify seizure of bank accounts, imprisonment of people for lengthy periods of time, imprisonment of pastors, closure of churches, locking people into their homes, locking them out of schools and hospitals and businesses, and preventing them from travel for business or pleasure. These things that happened during COVID, people have to really, as painful as it is, you have to keep these things that we experience vivid in your minds and recall them and how serious they are. And again, it's important for people to understand the context of the Bill of Rights. This Bill of Rights arises out of the ashes of the COVID lockdowns and the COVID experience as Alberta experienced it. But for COVID, there would be no black hat gang. There would be no Alberta Bill of Rights. And so therefore to import the Section 1 into it is just all that more offensive and frustrating.
No, I agree. The whole thing about the Section 1 is it basically means that if the government says that's demonstrably yada yada, anything after that is null and void. So it could, anything that we put in the Bill of Rights or anything that we put in the Charter that says bodily autonomy, property rights, etc., means no, under this circumstance, whether or not it's a climate emergency or whatever, no, it's demonstrably justified. We're going to go ahead and do it. So it doesn't matter all the rest of the stuff that we've put in. This is a showstopper for everybody that's watching, for sure.
Yes, so, that's a great way to put it. And the reason why I say that, I want to make this clear, is because of the way that this stopper, as you describe it, and that's a good analogy. It's a good metaphor.
Yeah.
The way it's been applied by the courts has been a blank check for government, and that's why it's so concerning.
Mm-hmm. So where do we go from here? Can we just get that part removed? Because here's the concern that we've gotten, and we'll get Scott LeVar on right away. But the concern would be, let's say the government says, nope, the only way we're going to do this is if we can keep this clause in. That basically means, okay, then you know what? Then we don't want to change the Bill of Rights, because even though it's got all this other stuff that we want, and the current Bill of Rights doesn't have this Section 1 clause, we're better off with the previous one than we are with the new one.
Arguably true. And I would go a step further, Kerry. I would say that if the government is going to go ahead and pass this bill in its current form, and I say this carefully because people know that I support the Premier and her government generally. I don't like everything that they do, but of course, if you agree with everything that your political leader does, then your political leader is probably Jim Jones. And you're probably being asked to drink purple Kool-Aid. It's a political party. It's not a cult. Yeah. And people need to understand that. On the whole, I support the UCP and many of their policies. A lot of the things that they're doing right now, I think are great. But if they are going to pass this bill in its current form, and I say this very reluctantly, it reduces this bill to the level of a political ploy to gain support. In other words, it makes it look like it gives with one hand and takes with the other.
Yeah,
and that's not really that cheapens what can be achieved through this bill. This bill, what we wanted it to be is a fundamental statement and expression of the values that Albertans hold dear and cherish, that we share, that define us. A list of things that every single Albertan, old or new, can agree on, that we all want to have as part of the society in which we live. And unfortunately, if this bill goes forward in its current form, as it appears it's going to, it's not going to be that. It's simply going to be sort of almost redundant, because essentially it really adds nothing to the current state of the law. It really will be, as the kids say, a nothing burger.
Yeah. As the kids say, Chris.
I don't think Chris sells those at the whistle stop, does he?
No, he does not. I did want to bring up this. This is kind of the schedule of how the bill was going to be go through. So here, October 28th, it was passed as a first reading. Basically, it's introduced. The actual bill itself is not, I guess, verbally read, but it's passed out. Yada yada. And then on the second reading, which is that was. Amory Mickey Amory had introduced that bill. The second reading, which happened yesterday, Daniel Smith read it. Actually didn't read it again, but she made about 15 minutes of comments on it and blah, blah, blah. And then it was kind of went around the house. There were a bunch of people made other comments on it, but essentially that's where it was. So the second reading is passed, and now it goes into what's called the Committee of the Whole.
Right.
And how long can that be like that, Leighton?
It doesn't have a time limitation.
No. So,
however, because the UCP has a majority, they can't. There are things that they can do to sort of close off debate.
Yeah.
The other side can do what's called filibuster.
yeah.
And keep the discussion going for a long time. I don't know yet whether the NDP are going to do that. I'm pretty certain that the NDP are not going to be at all critical of this section of the bill that I've been talking about.
No, you're right.
It's quite like the government override. I think they're going to focus on firearms,
bodily autonomy.
They don't think that property rights are very important.
That's right. Yeah.
They don't think very much of the right to the inviolable integrity of the human body. Notley, I think, said that at one point she said that she would have sanctioned the AHS workers coming to your door and forcing their way in and forcibly injecting people.
One of the MLAs actually brought that up.
Yeah.
During the
so that's we can criticize Danielle if we like, but you can see what it would have been like. I mean, the only thing that could have made COVID worse is if we would have had Rachel Notley as the premier.
Yeah. So then it goes through the committee of the whole, and then it goes to a third reading, and then after the third reading, it's passed. My concern right now, and this is where I'll bring in Scott and LeVar as well, to say, is there any way to stop this, or once it's in the machine, you can't put the brakes on it?
Well, it certainly is. It can be repealed,
okay.
or it can be amended. It can be revised.
Yeah.
They can table the bill if they like and go back and make revisions to it. I suspect strongly, based upon what we know of the UCP membership and its board governance, who were very much unanimously in favor of what we submitted, that is the Black Hat gang submitted to government, that they're going to have some very pointed concerns will be expressed about the bill in its current form at the AGM this coming weekend. And I expect there's going to be very, very lively debate. I was on a Zoom call last week with Scott, with some of those people from UCP leadership, and there were some real zingers. I mean, I was really hoping to answer some of their questions. Most of them very astute questions. Some of them expressing concern about protection of firearms rights and so on. One of the great things about the UCP, in my opinion, is that the party does have a great diversity of opinion, and that people's opinions are not censored. They have the opportunity to air their concerns, and I expect that that is going to occur when this bill is brought up, and I think it's going to be one of the central themes of the AGM this coming weekend.
Okay. Well, let's bring Scott and LeVar Payne on, and because good evening, gentlemen. They were part of the Black Hats. I should have brought my black hat down.
They are the black. I'm a phony black hat. They are.
Right. You're right.
Look at them. They are the Black Hats.
They look great in black hats too.
Yeah, Leighton, you're a real black hat. You're going to stand on the gallows with us. So.
They'll probably kill me first.
I'll go get my black hat later. So obviously, you guys have heard what our discussion is, and we've had Scott on before. LeVar, do you maybe just want to give a brief 30 seconds about who you are?
Okay. Well, first of all, I'm a former member of Parliament from Medicine Hat from 08 to 15 under Harper, and I'm what you call an 80-20 guy. 80% of what works, I'm supporting. 20% I can kind of go, okay, well, it wasn't everything I wanted.
Okay.
That's where I am. I'm much like Leighton. My wife and I decided we're not going to take these experimental injections. My wife is a nurse, and she was talking about all the billions of viruses that are out there. And as a result, we never did. And then we joined the freedom groups. And then I got together with my son, Scott, and a couple other boys, and we became the Black Hats.
Yeah. Awesome. And then you guys kind of took it amongst yourselves to look at this Bill of Rights and go, well, we can see things being trampled on figuratively and literally. what can we do to prevent this? And so you guys went through the Bill of Rights and made a lot of these adjustments, changes, additions, and presented that. And who did you present that to, and how did all that work out too? Either one of you can answer that.
Well, Kerry, it actually kind of started during COVID, as Leighton had talked about. And I would like to summarize everything I'm about to say is, what Leighton said. He nailed it. And you as well, Kerry, when you talked about that, that we can't have this bill as it is. So, I wrote a separate utopian Alberta Constitution so that the anchor of the Canadian government would drag us down with the rest of the provinces. And anyway, it morphed into a fellow who wanted to work with the Constitution. And we are 8 UCP members who wear cool hats. That's a summary. We're not some major group like APP or TBA or anything else. We're not collecting dues or anything like that. But we are UCP members trying to work within the party. So we actually started with a policy, this policy 15 last year. And so we got that policy, and it was essentially to expand rights and freedoms from the charter, add the following rights, which did include firearms rights and other rights, and in particular, add rights in the UCP members policy declaration. So every policy that had rights or freedoms, we went through that manual and tried to put everything into it. And it was all reasonable stuff, and it's what the members wanted. And then the final part was to protect those rights. And, we've presented to, we actually talked to Premier Smith in December 2022. And we talked to her again August 31st of last year. And in January, she said she was going to, December last year, she said she was going to send us to MLA Jason Steffen, chair of the Legislative Review Committee. And this is a quote: "He's as passionate about it as you guys are." And he is. And he phoned us in early January. We drafted our first version in 24 days, presented to him. And then timing is everything. We met Leighton, our constitutional expert, the following day. And we also met Shauna Sundell for the Irreplaceable Parent Project, Mitch Sylvestre, part of our group from the great constituency of Bonnyville, Cold Lake, St. Paul. He brought us all together, and he was responsible for the policy passing as well. And we met with MLA Steffen after Leighton helped beef up our recommended bill, made it better. And we met with him in middle of April. And then we presented to the Chief of Staff of the Minister of Justice at late July, and mid-July, I think it was, and then to the UCP board late July as well. So basically, people just need to get involved, show up, go to your constituency association meetings and learn. And that was part of our process. And, talking, and, what we wanted to do is not provide a problem for the government, bitch about rights. So what we did is we provided a solution, proved that 8 people from across the province could come together and develop a really comprehensive Bill of Rights. Now, people will be critical of it, about some parts of it, may like it, may not want it at all, whatever. But we gave a solution for the government that they can pick and choose from. And what we're recommending is a comprehensive Bill of Rights. Now, we got indications that it wasn't going to be comprehensive. And we hoped it was. I felt when the Premier put out her video a few weeks ago, talking about freedom of expression, bodily autonomy, firearms rights, I thought if that's all we got, I was going to be happy, not satisfied. I'd still be pushing for more, and we'd have a better bill. But as you discussed with Leighton, the Section 1 language that comes under from the Charter of Rights and Freedoms that comes under Section 1, subsection 2. It's basically a free pass for the government to pass any laws that they want, and then they're very likely to win in court, as Leighton's discussed. There's other notwithstanding clauses in the bill as well, and they added in I think it was parliamentary supremacy. Yes, and so that says the legislature may expressly declare an act that a law of Alberta operates notwithstanding this act.
Mhm.
So they got a couple ways around respecting our rights and freedoms. And that really needs to be a concern for citizens, I think. I know some of the reasons have been given that, well, what if a judge makes a judgment that's, crazy? And I would reply to that as like, well, there are courts of appeal. There is
Absolutely.
the Judicature Act, and we have, what is it, 9 judges on the Supreme Court? So if there was 1 or 2 loonies, I think on balance,
right. Yeah.
we're not going to have crazy things like that. So I think notwithstanding clause, we hear a lot about it in the charter, and everybody's ears perk up. Oh, notwithstanding, right? But nobody's ears really perk up about Section 1 because they don't explicitly say Section 1 when they pass an act. They're just like, okay, legal team, get ready for this one. Pull out the old Section 1 when we go to court. And so people don't think about it, don't realize it. And I think, we just need to, as Leighton would talk to, we need to remember recent history. So we go back to High River, the federal police force contracted to be the provincial police force, riding in army boats in a partially flooded city, mostly evacuated, knocking down doors while wearing weapons, and then pre-looting the houses before the looters could. Like, what an egregious breach of trust.
Yeah.
And that happened in Alberta, a pretty darn free province.
2013, the Great Flood. Yes, exactly. Yeah.
Yeah. And so we've advocated for rights. I mean, we saw what happened to Barber and Litch, full force of the government coming down. How long has their trial been going on? I thought it was supposed to be 18 months from charge to the end of the trial, according to the Supreme Court. In Canada, we don't have the right to have a lawyer present with us during questioning. You can talk to them before or after, and Leighton, if I'm wrong, let me know. But why wouldn't we want something like that? We need protection against the agents of the government. And those are some of the things that we're not seeing in here that we would like to see. And if they get rid of Section 1 and the language that is now subsection 1, sub 2, and if they get rid of the parliamentary supremacy, I think it becomes a bill that we can be proud of. We're not fully satisfied, but I think it's something that we can say, yeah, this is a good start at least.
Well, how would, at this point though, my question is so how would that happen if it went through? They're discussing it now, and then it'll go into a third reading. Do we actually, as bizarre as this sounds, do we actually have to call our NDP MLAs and tell them we don't want this, but we give them a different way of language? Like, is that what we have to do, or can we just call our UCP MLAs and say, you guys are close, but we need this changed?
Kerry, I just actually called a couple of MLAs tonight.
Okay.
And telling that they need to get rid of that section.
Perfect.
Standing clauses.
Yeah.
In the bill, and so that they need to amend, and they can do that, as Leighton has previously said. That can be amended long before it goes into law.
Yeah.
Because they don't have to pass the bill in third reading right away. They can take their time.
Okay.
And, then they can go make all the amendments they need to make, and so we're hoping that they get a big message from all of the membership that in fact they need to make those amendments and get rid of that Section 1 clause out of the Constitution, because that is just. And when I looked at it, one of the thoughts I had, that's a very nice Bill of Rights, but it's not worth the paper it's written on.
Yeah.
I think too, at this AGM, there's a chance that I think a very good chance that there will be a motion on the floor to have a comprehensive Bill of Rights. And this is an opportunity for people to vote for that. It's an opportunity at the AGM to talk to everybody. And like Dad said, you should be emailing all of your MLAs or your ministers. If you send an email to blackhatsab@gmail.com, I will send you a spreadsheet with all of the email addresses for all of the MLAs and ministers in the government. I don't think contacting the NDP will help. Maybe they would form a coalition in support of that charter language.
So
And
Scott, it's blackhatsab@gmail.com.
yes.
Okay, I just put that in the comments, and I will put that up on a banner. Continue on. Sorry, there.
Yeah, and it just we need to speak to them. I think not everybody reads into legislation like Leighton would or we would. I think it's important for when you have experts like Leighton that can bring these things out and others, and even John Carpe himself, Brian Peckford himself. Mm-hmm. Has spoken about it in past, and yes, John Carpe's article in the Western Standard of 2 days ago gives some really good examples of the bad that can come from. So mm-hmm. I give full credit to Premier Smith, all glory to God, for pushing Alberta rights and freedoms. Nobody else in the free world is doing this. Yeah. Now, I've been in the Army Reserve, and I've seen, brigade commanders and unit commanders, and they have all kinds of great ideas. And then they have staff, and, staff was tasked to draft this. And, it's not that she didn't read it. I'm sure she read it and understands it. But, if you don't listen to your staff ever, they're not going to be very good staff for you. And sometimes you take advice from your staff that is actually bad. And I think this is a poison pill, whether by accident or by design. Probably the latter. I think it really hurts what she's trying to do, and what she's trying to do is a great thing. Mm-hmm. And I think if we pass a good bill without some of the poison pills in this, it's a healing moment for the province. I want to see her sign a parchment, just as Trudeau the Elder did for the charter. She should sign it, and I think the government needs to reinforce it by getting peace officers, police officers, judges, lawyers, appointed elected officials to swear an oath to uphold, not only the Canadian Constitution and the Charter, but also the Alberta Constitution and the Alberta Bill of Rights above all other acts, laws, and bylaws. I mean, you look what's happening in Calgary. There was that pastor recently charged and then acquitted, if that's the right term, of the bylaw. It's not even like an act, right? It's a bylaw of a city where they can actually throw you in jail and fine you up to $10,000. Yeah, he's acquitted, and then today he just got notice that the Crown's appealing it, so he's going to have to go back to court in February because he protested outside of a library when the drag queen was reading to kids. Yeah. So we need to change the perception of peace officers, police officers who were horribly abused during COVID. Charging people, fining them, enforcing no hockey outside, types of things. We saw lots of kind of videos that they should be looking at, the complaint and say, hey, is this protected activity under the Bill of Rights? And if it is, then they should just pass on a business card. Hey, I'm Sergeant Carl. Hope everything's going well. Give me a call if you got a problem. And then they should walk away. If there's a crime, by all means, continue to investigate. But we need to look at the supreme law, our rights and freedoms above everything else. And that's how you read the Constitution. And even in this bill, they actually add in paramountcy. I'll just read it for you, which is really good. And that, I think, is the same verbiage from, I think it's Part 5, Section 52 of the Constitution.
That's correct.
But it says, paramountcy, any law of Alberta that is inconsistent with the provisions of this act is to the extent of the inconsistency of no force or effect. But then they follow up with the parliamentary supremacy, which just kind of kneecaps what they just said. So anyway, I think it's, a very good start. Take out the poison pills. We can build on it, hopefully through amendments. But yeah, talk to your MLAs and try and be positive that, hey, thanks for doing this. However, you got a big problem here. Let's fix that one. And then
for sure. We were all excited about it, and we knew that it was going to be introduced in the first couple of days. I mean, even I was on the same Zoom call as Leighton on Saturday, and Daniel Smith said, "Oh yeah, we're introducing it right away, and it's going to end up being law by the end of November." So we were all excited about it, and then we didn't get the actual verbiage of it, and then Leighton sent me the copy and took a look at it and kind of went, well, wait a minute, I've seen this before.
Yeah.
So what Scott says is a very good example. example he gave of the gentleman who protested the drag queen story hour.
Yeah.
So there you have a person who is exercising their constitutional right to protest, freedom of association, right, and freedom to congregate, and freedom of speech and of expression, and a bylaw, a mere municipal bylaw, results in the deprivation of his liberty and the violation of those protected charter rights, which are supposed to be supreme. They're part of the supreme law of the land.
Mm-hmm.
But that going before a court, if he went before the court and if he argued that his freedom of speech and of expression under the new Alberta Bill of Rights were violated under the existing legislation, a court would consider the safety and security and the public interest in the safety and security of LGBTQ people and of the children attending and parents attending the Drag Queen Story Hour event, and would find and could find and probably would find, based upon, you know, the sort of victim hierarchy that our courts tend to follow, that that the violation of this man's rights, constitutional rights and rights under the Alberta Bill of Rights, are demonstrably justified in a free and democratic society. The other thing that I agree with what Scott just said is, this is going to sound funny coming from me. I think the culprits are the lawyers. The lawyers are giving the premier and her cabinet advice that I don't think is good advice. And it sort of reminds me of a piece of scripture, Luke chapter 11:52, which says, this is Jesus talking. He says, "Woe to you lawyers, for you have taken away the key of knowledge. You did not enter in yourselves, and those who are entering in you hindered." In other words, you've taken away. You won't enter into, sort of the realm of knowledge, like the kingdom. And in fact, you're leading other people astray. You won't let other people enter in so they can know the truth. And I think that kind of applies here. The lawyers are kind of leading things astray. I'm giving her, people might say, well, I'm giving her too much license, giving her the benefit of the doubt. But it's true to say that she seems to be very interested in protection of rights and freedoms. But, the premier is a very smart person. She's well educated and well spoken, articulate, but she's the first to admit she's not a lawyer. And of course, a wise person knows what they know not. And so she's deferring to the lawyers, the justice lawyers, who are saying to her, well, we've got to have this saving provision in there. And I think that's why it's here. I'd be interested to know how lively the debate was over whether or not this provision got into the bill. I'd be interested to be a fly on the wall during those discussions. But I do agree with Scott that it's probably there because that's the legal advice that the premier or cabinet are getting.
Yeah, and who authorized it, and really who did lobby to have this thing put in, right? And I mean, there could be a bunch of different reasons. It could just be a copy and paste. Oh, it was in the charter, let's use it. But like we've discussed already, it was put in there, and it's had so many eyes go through it that they would have known that what it was and where it came from and the reasons behind it. So that's kind of where we are with that. But what I did want to bring up is that Scott LeVar had sent me a revised version, I guess, of the bill as you've done it. I can present that now.
Kerry, that the file I sent you actually is
merged.
What the new bill will look like with the amendments from Bill 24. It's not our work. I just took Bill 24, took all the stuff out, put it where it would be in the in the new bill, and it's got the crossed out stuff of what will be repealed.
But I can show it, right? That was my point. Yes, and actually, I will. We'll put it online so that people can take a look at it in terms of here's good and there's bad.
Yeah. Anything that's green is newly added. Yeah. Anything that is stricken out is to be repealed. Yeah. And just some of the offensive text is written in red. So
Okay.
there's probably other things I don't like. I've got another stuff I'm working on, but it just gives you an idea what it will look like based on my reading of Bill 24. And if I've made a mistake, I apologize to anybody who wants to point it out.
Yeah, well, maybe we won't necessarily post it right now, but we will give you the opportunity to make a cleaner version of that. And then, but again, you're going through all this extra work. Kudos to you guys for doing this grassroots right from the get go. What can we do with this document? Can we actually present this as a revision? Again, my big concern is that if this thing is going through right now, how do we put the brakes on it, or how do we make those changes before any damage is done?
Well, you need to show up at the AGM, and you need to talk to MLAs when you see them on the floor, or the premier, any of the ministers, for sure.
Yeah.
If we do get to bring our bill to be presented in a special resolution on Saturday at 11:30, then I recommend you vote for it. Now, it won't be a binding motion that the government has to follow. What it will be is an expression of the will of the membership that, yes, we want a comprehensive bill. Part of our reasoning is, to use the Premier's words, that the most dangerous time for this federal Liberal government will be in its waning months, or its last month. And we've seen, and Leighton might be able to explain these a little bit better, but Bill C-21, the red flag law. So if you have firearms, they can complain about you. You won't have committed a crime, but they're predicting a future crime. So they can take, invade your house, take away your guns. Bill 63, the Online Harms Act, suppression of freedom of speech. There's a lot of requirements for social media providers that are going to cost time and money, and limit freedom of speech. And it's also an opportunity for them to determine what hate speech is. So just like we don't like them to determine what is a demonstrably free and fair society, we don't really, I think, want the government to determine what's hate or what's truth. And that's what's happening. And that stuff is coming down the pipe. And then they have Bill C-293, which I think is at the Senate now.
Yeah, it is. Yeah.
Pandemic Preparedness Act. And what really, I would retitle it myself facetiously. I would say, be prepared to take advantage of the next planned pandemic, because it's talking about stuff like, shutting down packing plants because they may be a source of infection, looking at alternative forms of protein, looking at expropriating land, all kinds of really draconian things. Like, if you thought COVID pandemic or plandemic was bad, wait for the next one, because they're going to be much more prepared, at least legislatively.
I was going to say, during the first one was almost like a test, and it was like, okay, so where are the holes in this dike here? We got to plug those things. Yeah, and sure enough, that's what they're doing legislatively.
Yeah, and if you think the police were used poorly in the last one, they're talking about many more agents of the government.
Yeah,
and interrupting the food supply chain, that's pretty egregious. And then we've seen all kinds of inflation the last few years. Yeah. What will happen at the next one? Devalue everything we have? Like, it's scary. And one thing about Trudeau, and maybe he doesn't survive in another week. Maybe I'm wrong, but he's basically thrown the water off his back regarding the 20 or so MPs that are calling for him to step down. If he survives that, next March, he could say, you know what, we don't have enough time to fix all the things we wanted to do. So we're going to change the Canada Elections Act again. And we'll just take it back to the Constitution that allows us 5 years. So it could be more than 12 months. It could be 24 months.
Yeah, that's true.
And, and people forget that he's not actually the problem. He's the symptom. He's got his own caucus and the NDP caucus, and at times the Bloc caucus, who supported all of this stuff, whether it's freezing of bank accounts during the Emergency Measures Act or any of the other stuff that's happened. Like, it's crazy.
Yeah.
So this is an emergency. We need a strong Bill of Rights, and this is part of the reason that we put it forward. So we provided a solution. The government needs to provide the solution.
And again, to just reiterate what you were saying about the various bills, 293, 63, even if we had a strong Bill of Rights, let's assume that we don't have this demonstrable clause, section 1. We've removed all the parliamentary situation in there. Again, we've already said that it's not everything that we want in a Bill of Rights, and things can be changed. But if we were to run into that sort of situation again, where there is a pandemic or something like that from outside of Alberta, would this Bill of Rights actually protect us in Alberta? Could we actually use it?
Well,
go ahead.
Well, one thing that's important for people to understand, I said off the top of the show that I do support a lot of the things that the Premier is doing. And one of the things, just tying into what Scott just said, talking about Bill C-293, the government of Alberta has said they're not going to enforce that law because it overreaches, it violates their constitutional authority. A Bill of Rights is all fine and good, but to quote James Madison, it's really just a list of promises that government may or may not keep. The most important protector of freedom in the country is something that I find Danielle Smith's government is doing quite well, and that is to actually uphold the structure of federalism and the separation of powers. A lot of Canadians, I actually had a poll on my X page asking Canadians whether or not they thought Canada had a national government. And nearly 40% of Canadians think that we actually have a national government. We don't. LeVar will tell you, he served in Parliament. We have a federal government that is sovereign and supreme within its designated powers.
That's right.
We live in a confederation. And within that we are a confederation of sovereign states called provinces. And so the provinces are sovereign and supreme within each individual province. And this is because the people who framed our Constitution, the great vilified people like Sir John A. Macdonald and others, they were actually very wise men with tremendous foresight. And they saw that Canada is a very vast, diverse country with many different languages and cultures and dances and art forms and all kinds of things. And so it was very important for local government to have power to affect change close to people's doors, because that's the most important government there is, the one that's closest to your door. And actually, people don't realize this. Your town councillors and your mayors actually have as much or more impact on your lives than the Prime Minister in Ottawa does. But we don't have a national government, and because the provinces are supreme within their jurisdictions, there's no constitutional requirement for them to enforce federal laws. And so this was proven. Another great thing that Danielle Smith and her government did is when the federal government wanted to confiscate everyone's guns, Danielle Smith said, we're not going to enforce that law in Alberta. So I find that we, as critical as we are of this particular bill, in a lot of ways, we're sort of focusing on the small things. In the big picture, she's doing a lot of things to support the freedom and prosperity of Albertans by just standing up to this tyranny and enforcing the greatest protector of rights and freedoms, which is the structure of federalism in the form of the constitutional sovereignty of our province. And I don't think there's any political leader anywhere in Canada who's doing as good a job as she is of that. So it's important to say that and just kind of explicate what Scott was saying. These individual rights and freedoms are important, but really what we're up against is not so much our provincial government. Our provincial government these days, unlike when Kenny was there, our provincial government is not doing very much to violate our individual rights and freedoms. At least if they are, I'm not aware of it. I don't find that the Danielle Smith government is a great human rights offender. But this federal government in Ottawa, as we've said, everywhere on all fronts, is trying to control every single aspect of our lives. And that's why I see the Bill of Rights, the most important thing that it does, in my view, is it is an expression of Alberta's sovereignty. That Alberta can say, you know what, Ottawa, you have your charter, we're Alberta. We have our own values in our province. We're sovereign within our province. This is our Bill of Rights. This is what we say is an expression of our values, right? And so I think that maybe that more than anything else is the importance of the Bill of Rights, both historically and practically, leaving aside the legal part of it. But I have to say, on the whole, in the big picture, there are a lot of things that Premier Smith and her government are doing to protect the individual rights and freedoms of Albertans, simply by being sort of an iron dome against federal government overreach.
Absolutely.
Do you think that this current version of the bill is being presented right now is designed to be a two-step approach to do the sections that I think as conservatives are most looking forward to: bodily autonomy, gun rights, property rights, that sort of stuff, and then everything else will be looked at later on, like maybe next year?
Yeah, that's a great point. And one of the things that I heard the Premier Smith say during that Zoom call that we talked about, and I hope I'm not speaking out of school here. I don't think I am, but she said that she said something that I've been saying quite a lot, and that I was hoping that her government would pick up on. And that is the great potential of Section 9213 of the Constitution, which is the exclusive authority over property and civil rights. And I've said many times that really, there really isn't any aspect of our relationship with government that doesn't come under the scope of property and civil rights. And I heard the Premier say, in answer to a question about whether or not the federal government has exclusive authority to legislate with respect to guns, and she said very clearly that firearms are property and that they are under provincial authority, provincial scrutiny, provincial jurisdiction, and that she was prepared to go to court to fight that out. That's an example of what I'm talking about, where the Premier is using the structure of federalism, the black law in our Constitution, to defend and uphold our rights and freedoms. There, she's upholding the rights and freedoms of individual firearms owners in Alberta by using the structure of federalism, that's there in Section 9213. And she quite rightly said, and she said this publicly, but she also said it during the Zoom call, is that the provincial government has had a lot of success in the courts in getting the courts to tell the federal government, look, guys, you're outside of your lane. It happened in the Emergencies Act case with Justice Mosley. It happened in the plastics reference. It happened in the Bill C-69 reference. And now, just in the past couple of days, she's announced that they're going to revisit the climate tax, because the federal government applied the carbon tax in a very discriminatory way by providing special breaks to Eastern Canada over their special oil heaters.
That's right.
And none of those climate tax breaks were provided to people in Western Canada who use natural gas. Clearly discriminatory. So again, another example of her government using the structure of federalism to protect the individual rights and freedoms of Albertans. Not necessarily part of the Bill of Rights, but still protecting the individual rights and freedoms and the interests of Albertans by effectively using what's there in the Constitution. And I foresee, and I hope this is true, that we're going to see more of this from the Alberta government, using and sort of flexing its sovereign power under the Constitution, because that's something that I predict that appellate courts, even the Supreme Court of Canada, are going to be prepared to accept and to acknowledge. They've been very consistent in their interpretation of the division of powers between the province and the federal government. The one exception being, the original carbon tax reference, which I think, and I've said this before, and I don't mean to throw rocks at anybody, but I think that the province would have won that if it had been argued differently. That gets a bit technical, but I think that case could have been won. The approach that they took, in hindsight, with the benefit of hindsight, I think they could have won it if they would have taken a different approach. And I think that's part of why they're going back now and revisiting it. And I think with that wisdom and that experience, I think this time they have an excellent chance of using what they've learned in their successful jurisdictional challenges to defeat the federal government. In fact, I would not be at all surprised that the federal government just simply back down and not take the chance of having the case actually litigated before the courts, because what they did there with the carbon tax is completely indefensible. It was a pure cash grab of Albertans and people in Saskatchewan and other provinces. And I hope that Mr. Moe, recently re-elected, is going to join in that carbon tax reference, just the way he did last time when Mr. Kenney brought the carbon tax reference.
So we've covered quite a bit of stuff. We've really focused on just that one clause. So hopefully we can get that changed, and things will happen in the amendments. And again, if anybody's watching and you want to get involved, I'm just going to again put in the comments here, blackhatsab@gmail.com, to get the list of your MLAs. I know Benita Peterson was also, I saw in the comments, posting the list. That's great too. Thank you so much. And I'm going to rely on everybody watching and sharing this video in order to put some pressure on the MLAs. Now, granted, we only have a couple of hundred people watching right now, and these videos can get out to 30, 50,000 people or whatever. We still need a lot more than that to put the pressure on the government to say these are the changes that we want. So I'm relying on everybody watching in order to do that. So there's your task for the next couple of days. If we can make that pressure before the AGM, that would be great. Otherwise, we have no idea how long it's going to actually be in the committee of the whole, and then we'll kind of see where it goes from there. But again, great to have these conversations and so much to learn, and there's so much more to go. And I'm pretty sure we'll end up having another discussion about this in the next couple of weeks. I know we even, on the Alberta Prosperity Project webinars that we do on Wednesdays, we brought up 293 and 63, all those. I have Sharon Polsky, who we've had on before. She's out in Ottawa right now talking with the senators and in the Senate to see what's happening with that. She'll be reporting back on that in the next couple of weeks. Hopefully it's not too late to do anything about it, but if it is, then it's definitely a good conversation to say, so what can we do now? And I certainly don't want to be having the same conversation with us. Oh, look, it's passed. Now what do we do? Right? In terms of the Bill of Rights. So I want to at least see what we can do with that. We did have a couple of other people. Obviously, Dennis Modry didn't get on with us, and neither did Mitch. I haven't heard back from Mitch. They're probably still scrapping it out up there. But we do have Marty Mayer on here. I'm going to bring him on because he's sitting in the back, and I really like his hat. Hey, Marty.
Hello, guys.
We were going to bring you on, and still will, obviously. About property rights, because you've been looking at property rights and how the property rights clause works in the Bill of Rights. Is there anything that you want to add to the conversation about, basically what your thoughts are on the Bill of Rights and the property rights?
Well, when you consider who else is on this podcast, it's going to be really hard to add anything of value, but I'll try.
Yeah.
And I'm going to quote somebody, William Pitt, who was a British prime minister in the late 1700s. This was his position on property rights. The poorest man may in his cottage bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter. All his force dares not cross the threshold of the ruined tenement. So that's my idea of property rights.
Mm-hmm.
Now, anybody else on this podcast can correct me here, but what I'm reading, it says the right to enjoyment of property. In Alberta, we don't own property. We just enjoy property. And it says the right to the enjoyment of property, the right to not be deprived thereof, except to the extent authorized by law and except by due process of law. And it says the right not to be subject to a taking of property, except to the extent authorized by law and where just compensation is provided. So I see the one as you have property rights and we can't touch it. The government, the king, can't touch it. And I see the other one as what's being proposed here is the formula on exactly how we're going to take your property when we want it.
You're right.
Here's the formula. We're coming for you. We're going to give you what we said we're going to give you, and good luck fighting us. That's what I have to say about property rights. I'll stay in my lane and limit it to that.
You make a great point, and actually, what you just said, this formula, if you connect the dots, it ties right into this section 1 of the charter that they've imported. So if you sort of cast your mind out into an example of someone's property being taken, and they claim they assert their right under the their property rights under this Bill of Rights, and then they run into the formula, and the formula is deemed to be demonstrably justified in a free and democratic society. And so you see how the different how the tapestry is woven together here. And in the net result, when everything goes through the rinse cycle, it doesn't really protect individual rights and freedoms as much as William Pitt, who is, by the way, majorly responsible for emancipation of slavery in the British Empire, along with Lord Wilberforce. It doesn't really fit the standard that he was talking about in that quotation. And that quotation is what the Black Hats really were all about in terms of protecting property, because we know from going around and talking to people in this province that property rights are vitally important to Albertans. And in fact, when you look at history, in fact, going all the way back to the Old Testament, look at the 10 Commandments, and you'll see it's all about the property. Thou shalt not covet thy neighbor's wife. It's all there. Thou shalt not kill, or thou shalt not murder. Even treating the individual life, human life, as a property right that shall not be interfered with. So all the way back deep into the Old Testament, which is really the fundamental pillars of our law in the Western world, the protection of property has been linked to freedom and individual liberty and prosperity and protection of the family and of the nation state from time immemorial, for as long as we've had recorded history in Western culture, all the way back to the Old Testament. The protection of private property has been absolutely essential, and every place it has been lost has fallen into totalitarianism. Every single place, without exception.
Absolutely.
So I might just add, when we're talking about property, and a lot of times we end up talking about our homes, but the property can also be your car, it could be your bank account, it could be your rifle or whatever. So it's not strictly just your home or your land. It could be any of those things.
That's any property, anything that you can see, touch, smell, taste. I would imagine that could be property as well. We have a few questions there, but not a lot. I think we've answered a lot within the last hour and a half. But so Shirley asks, wondering if the federal government would challenge the constitutionality of our Alberta Bill of Rights, such as in the case of firearms, other property, that sort of thing. Anybody want to jump in on that one?
That's a great question. It's one that is often asked, and it's an open one. I can tell you what the Premier has said. The Premier has said that she's prepared for that. As I said earlier, her government is taking the position that a firearm is a species of private property, that under property and civil rights, Section 9213, that's provincial authority. The federal government does not have exclusive authority to legislate with respect to firearms. They have under Section 9127 of the Constitution as exclusive authority over criminal law. And they have expanded and overreached that power to extend into some sort of universal authority to legislate regarding firearms. And in fact, the punishment and restriction of firearms ownership of people who use firearms to commit criminal offenses is something quite alien to the concept of responsible firearms owners. There's more than 3 million of them. And if there were actually a safety concern surrounding responsible gun ownership, legal gun ownership in this country, we wouldn't be able to go out of our houses. We have had bullets flying in through the windows. The fact is, and I've said this publicly, we might have the most responsible set of gun owners in the history of the world. We might be the example for all time, for all societies, for the most responsible gun owners in the world, given the number of guns we have, for example, in Alberta, and the number of offenses in which firearms are used by legal and lawful firearms owners. But I think this lady, Shirley, she puts her finger on something that's a question that's very important, and it's one that very well may be litigated. But I think that that the province and the premier is very prepared for that fight.
Yeah. Watto 76 asks, the last amendment to the Alberta Bill of Rights was 1972. If you don't get everything you want in this now, how long do we have to wait until we can amend it again? And what will include what was missed?
Well, 72 was not actually an amendment. It was the original bill.
That's right.
I think it was one of the first bills that Premier Lougheed brought in. LeVar will correct me, but I think it was one of the first bills that Premier Lougheed brought in his original Conservative government. And but it's a great question. How long will we have to wait? I hope it's not another 52 years. What you want to have with the Bill of Rights is you want to have something that becomes relevant to the people of Alberta, that becomes part of them, part of the fabric of Alberta life. I'm not convinced that the original Alberta Bill of Rights did. It maybe didn't have the chance. It was maybe usurped by the Charter, which came only 10 years later. This Bill of Rights, if it's done right, has the potential to be something much more important and relevant to Albertans. I would like to see that it grow and sort of develop along with the culture of our province. But fundamentally, a Bill of Rights should not have to change too often. I mean, really what we're talking about are the pillars of our society, right? If you have a society that Justin Trudeau and the Liberals in Ottawa imagine, one that is full of moral relativism and the absence of objective truth, and which with no sustaining shared values, a post-nation state. Well, that type of society doesn't need a Bill of Rights, but Alberta does need one. But fundamentally, the greatest thing that the Bill of Rights does is it's a statement of our shared values and what's important to us and what binds us together and what makes us Albertans, things that we can share that allow us to live prosperously and peacefully together.
Yeah. And even the portion of the freedom of speech, even just 10, 12 years ago, the social media certainly was not the way it is now. And here we have something, C-63, the Online Harms Act, that needs to be addressed. But looking at what the Bill of Rights would do, it would protect us anyways, if you want to call it that, from overreach, freedom of expression, all that. So I think, obviously we couldn't go in and redo these Bill of Rights every year, but I think because we've tabled a few things, I believe there was 27 originally. Is that right, Scott? Yeah, there was 27 items on there.
29, and then
okay.
Leighton helped refine that.
Yeah.
And just speaking about it though, we talk about the Harper and Morton firewall letter.
Yeah.
The Alberta Bill of Rights, and as Leighton was talking about, the distribution of legislative powers, exclusive legislative authority for the provinces in relation to these matters, including property and civil rights. This becomes the individual firewall for the individual Albertan against all levels of government. Could be the government of Calgary, and it could be the past UCP government, and it could be the current federal Alberta government and any other future governments. Yeah. So, I think there's a lot more we can add to it. One thing I would really like to see is a slight change to what they have for parental rights. And it's just adding a few words. And, we're just calling for freedom of parents to make decisions concerning the health, education, welfare, and upbringing of their children. And just right now, it's to make informed decisions respecting the education of their children. Yeah. So let's add in that health, welfare, and upbringing, because we need to recognize And whether you want to call your kids property or not, they are our most important treasures.
Yeah.
And family is the bedrock of society. And we need, it's a small group of activists, teachers, and other bad actors that are interfering with that. And I think we need to express that very clearly in this new Bill of Rights when it is finally passed.
Mm.
So
here's
about that sucker.
Yeah. Here's another great question from Carol. She says, what prevents the next government from coming in and changing it?
Yeah, that's a really good question that was actually raised on a recent Zoom call. There's a couple of things. Firstly, I'll point to the fact that it's been 52 years, and no Alberta government has changed the original 72 Bill of Rights. So that, in a way, that sort of speaks for itself. Secondly, although it is possible for, let's say, heaven forbid, Mr. Nenshi, if he ever became premier in the NDP government, to come in and repeal the Bill of Rights, but try to imagine that. That would be an incredibly risky and unpopular move that would alienate many millions of Albertans. For a government to come in and repeal a Bill of Rights, my goodness, that is something that I don't think I hope no Canadian government is ever going to do. I think a bigger concern is not having a government change the law. A deeper concern is what we've been talking about tonight, and that is the government using provisions of the bill to really defeat its fundamental purpose, and that is the protection of individual rights and freedoms. And this is why, when we're talking about how the wording of the property protections are made so that it provides sort of an escape clause for government. When we talk about how this demonstrably justified in a free and democratic society can be used to uphold and justify violations of the freedoms in there, I would say that's a much more serious concern. That's how governments historically have gotten away with violating the freedoms and undermining what's in a Bill of Rights, as opposed to just coming out and repealing it. In fact, I don't know of any government in the history of Canada that's ever repealed a Bill of Rights. I don't think that's ever happened. Even in 1982, when we got the Charter of Rights and Freedoms, the federal government did not repeal the Diefenbaker 1960 Bill of Rights. It's still on the books.
That's right. And especially, like, what would they take out? No, we don't like that phrase about bodily autonomy.
Yeah.
Like, I don't know.
There's just smarter ways for them to do it.
Exactly.
Based on, and this is why it's so important that some of the things that we're critiquing about the bill need to be changed, because governments are very clever. Their lawyers are very astute, and they'll find the loopholes. They're laying down, the tracks for those loopholes to be used. And this is why we're expressing concern, I think justifiable concern, about the way certain parts of the bill are worded.
Yeah. A few people have actually asked as well. Brian says, is this being recorded so I can watch from the beginning? He's black hat number 4. So you guys would know. Yes, as a matter of fact, it is. It is currently live, and it's being held on the APP Rumble and YouTube, and it's on Facebook and on X, as well as I go back and I repackage this and put it under the Chris Kerry Show. So you can go to the chriskerryshow.com and any one of our social media as well. But thanks for watching, and thanks for that question as well. And with that, there's a couple of more. I'm going to bring up Bonnie asked this. Bonnie, who we love and adore. She says, I see from today's Ledge Notes that this has gone to committee with amendments. What do you make of that? And we've kind of touched on that earlier, that that's good. I mean, that's the whole reason why it goes to the committee of the whole, is maybe these changes will happen. We don't know, right? And that's the question that we've got, is that we won't really know any of this until the third reading. So if anybody's out there, then they're they're listening and saying, yeah, how do I get involved? Again, just send a message to your MLA to say, no, I don't agree with that particular clause. And likewise, we'll even have the copy of the bill. I'll put it in the show notes so that you can always take a look at it. And that's kind of a live PDF document, so that they are making amendments to it. So it's not like I have to keep updating with that link. And then I'm gonna something a little controversial, but it's from our good friend Chris Scott up on Vancouver right now. He says Danielle needs to stand up for Albertans and fulfill her role as a champion of the rights of Albertans. She needs to be the leader we know she can be. So there you go. Wise words there, Chris. So again, we've covered a lot. Any final thoughts from any of you? Maybe we'll Marty, you came on last, so do you want to go? No, you're all good.
Yeah, I'm good.
How about LeVar and Scott? Anybody there with any final thoughts?
No, I don't think so. I mean, I think we touched on pretty much everything we need to.
Yeah.
I'm not a pastor, but speak now or forever hold your peace.
That's very true.
Critical to get involved now.
Yeah. And I know I don't even have to ask Leighton if he wants to have any last words, because he always has the last words because he's a lawyer.
Yeah, well, I think I agree with Scott, and I'll just maybe expand the point a little bit. It's very important that we continue to engage with government. We continue to have the conversation. Mm-hmm. We are fortunate that in Alberta we have a government that shows that it's prepared to listen to us. This is something that they do have regard for grassroots. Now that doesn't mean we're going to get everything that we want. This isn't Christmas, and Danielle's not Santa Claus, right? Mm-hmm. But what's important, what I would say to people watching this, if you're discouraged or upset because maybe the bill didn't live up to what you thought it was going to be, or maybe what the black hats wanted it to be. The important thing is that we keep working with government. We continue to have these conversations, and we continue to push for what we think is best for Alberta, for Albertans. I tend to think that this government wants the same thing. They also, however, have the practical problem of remaining in power. Mm-hmm. And sometimes there's a yin and a yang. There's a push and a pull there. LeVar knows all about that from being in Parliament. And so what I'd say to people is, look, instead of getting upset and getting on Twitter and calling for Danielle to resign, you talk to your MLA, talk to your neighbors, come out to the AGM, get involved in the conversation, because we do have a government that will listen, and and that's a blessing. And the grassroots movement in Alberta is stronger than ever, and I think this is just really one of the best examples of that right now. The Black Hats gang. I'm very privileged to be accepted by these people. These are wonderful men, and I admire them all very much. And I want people to know how much they care about their fellow Albertans. That's why they're doing all this. They're not getting paid millions of bucks.
No, not getting paid at all.
And those hats are expensive.
Not at Lamley's, they aren't.
Well, that's great, gentlemen. Thank you so much for your time and your effort and putting this Bill of Rights and being involved and being on the show and discussing all this. I will be wearing my black hat because I have to. That way, at least it looks like I'm actually the size of most men.
As long as you wear a black hat and not a black cat, you can wear a black cat for Halloween, Kerry.
That's right, exactly. Yeah. So I'll be in the black hat. But everyone, if you're attending the AGM, please wear a black hat. I know I've also received some critiques about why does it have to be black, and it's like, you know what, just wear a hat then. In solidarity, if we all go in there in hats, then great.
I'm wearing a red one.
Those little fashionistas or whatever they're called, the little tiny hats that the women wear. Yes. We digress, but no, it's so good for you guys to come on. Thank you again. And again, once again, we do this every Wednesday. We definitely try and do this every Wednesday, or I try and do it every Wednesday. And we're going to be doing one next week, basically just about So what happened at the AGM? And was
Yeah.
it good? Was it bad? Do we have a new leader or a leader ousted? I mean, I certainly don't want to go down that road, but you know what? It's a possibility. And I think we need to show up and voice our opinion. And by all means, I'm sure if all of us are there, for all of our viewers out there, please come and say hi to us. I'd love to be able to have a conversation. That's why I'm there. I actually took the weekend off in order to do this. So I'm definitely there for the long run. And yeah, I'll definitely be shaking the hands of all you guys as well. So thank you again. And with that, I'm going to wish you guys a good night. And I've got some packing to do in order to get stuff ready for the weekend. So with that, you guys have an amazing night, and we will see you guys soon. Cheers.
Okay, you're looking for us. Look for guys with black hats.
Black hats. It's got to be black hats. All right. Thanks, guys.